And we'll go to you. Hello, thank you for showing up. We have a very special episode. This is part of our continuing series on the lawsuit between the Texas Nationalist movement and their president, Daniel Miller, and Meta, also known as Facebook, concerning the new Texas law about how social media companies cannot ban or censor content from conservative voices. We're talking about the actual first lawsuit test of this brand new Texas law, and it's going up against nobody but Facebook, one of the largest social media companies out there. We have with us a very famous lawyer, Sean McBride. As you see in the title bar below, Sean is able to practice in 12 states. That includes Texas and California. We're going to be talking about this case today, the Texas Nationalist Movement and Daniel Miller individually versus Meta Platforms, the INC case number 122CV 00572 MJT. And it's going to be argued by in front of Judge Michael J. Trunkall in the Eastern District of Texas. We have more details, but before we get to that, watch this real quick and we'll be right back. We're going to get to Sean McBride here. You can see him here in just a second. He's going to give us our expert analysis, but I wanted to cover some of the basic information you may have seen before we get to the lawyer. So we're going to cover some of the basics, and then we're going to go to Sean, and he's going to walk us through his professional legal interpretation. But just to remind everybody what we're talking about. So basically, here it is. These are the key legal documents. Plaintiff's response to defendant's motion to transfer venue, Texas Nationalist versus Meta. Here's another key document we'll be looking at, defendant's motion to transfer. And then finally, this document, defendant's Meta Platforms motion to dismiss. It's being argued in front of this judge at this court case here. Here is Sean's website. I encourage everybody to check him out. Sean McBride. He listens to your dreams and he helps you achieve your goals. Finally, this is part of our continuing coverage. We did an interview with Daniel Miller a few days ago. He actually launched the website and we covered the website itself. So now we're going to talk to a professional lawyer about what does this all mean. I'm going to go to Sean real quick. I do need to show people this one more time. Okay, so here are the key arguments. Meta's motion to dismiss on page 11. Meta blocked their links from going to the links for the Texas Nationalist Movement. And they say, plaintiff also makes clear the disputed link promotes Texas secession from the Union, and in that the Supreme Court has said would violate the Constitution according to Texas versus White. There it is. Meta's motion to transfer also includes Meta pointing out that TNM wished to compel an out-of-state online service provider to disseminate content promoting secession from the Union. In an ordinary case, the court would simply reject this law-defying request. So there's Meta saying that again. Here's the Texas Nationalist Movement response. There is no provision in the United States Constitution or Code that prevents states from exiting the Union. So there you go. Those are the basics. Sean, let me go to you. You saw the earlier videos. What did we get wrong? What did we get right? How would you summarize this case, having looked at it, sir?
Well, there's a couple different layers here. So one layer is, will the court even get to this, right? Because at issue is claim on what Facebook may or may not have to publish on its platform. So we need to remember kind of what the core legal arguments are there. So one of the issues that we're going to be dealing with is, will they even get to the question you're asking, right? Which is, is secession allowed or not? It's a secondary question from the court's perspective, right? And I think as we get into this, what we're going to see is some First Amendment arguments, compelled speech arguments. We've seen some of these state statutes popping up here after the election and all the potential changes where they're trying to say don't censor on one point of view versus another, but the courts have not liked these statutes in general. So one of the first questions is this Texas statute valid? I know based on your videos, the very important question that you want to get to is, can a state potentially leave the United States? The court may or may not get that far down the analysis because, one of the things may happen is they may find other reasons to get through the case without getting to that question, right? The court doesn't necessarily have to resolve every question, every case. In fact, as you get into more higher level, more sophisticated litigation, it's very common for the court to decide the case on one or two issues and leave some of the other issues unresolved for future cases. That's generally efficient for the court to not have to go through everything. It saves them time and effort. And if they can find one avenue that is dispositive, gets to a final answer on who wins or loses the case, they may not go into the other issues. So I think that's a big thing we just have to keep there. And I would not be surprised if the court sidesteps this issue by looking at other issues in the case, finding out that one of those issues leads to one party or the other winning or losing the case, and therefore they don't get into this deeper constitutional argument that I know you and the Texas folks are very interested in.
So let me summarize what I think you're saying. Tell me if I'm getting it wrong.
Yep.
This lawsuit has a couple issues. There's a Texas law saying, hey, if you're a social media company, you can't censor, but it's a brand new law.
Right.
And Facebook is going to probably challenge that. There's some free speech grounds. There's some, hey, we're running our own business, you can't tell us what to do grounds.
Sure.
The first test case of this law. So that whole argument may jumble up everything, right? And we may not even get the session argument because they're just going to spend all their time and spin their wheels focusing on that.
And exactly. And if that argument over that law determines the outcome of the case, they may not get to the secondary issue of whether whether it's lawful for somebody to secede or not, because that's kind of it's a secondary issue embedded in this case. So they may or may not get that far down the line.
What about Facebook's trying to get the case moved to California, and TNM is saying, no, it belongs in Texas. You violated us in Texas. The event or crime or whatever you want to call it occurred in Texas, and Facebook's going, yeah, well, maybe it did, but, we're based out of California, so you have to come and get us in California. And the Texas Nationalists are saying, okay, but you violated us in Texas, and you're trying to say you're exclusively a California thing. And there was one line in the Texas lawsuit that made sense to me. They said the idea that Facebook, even though they're outside of Texas, doesn't have tentacles or something involved in every part of Texas politics or discussion is ridiculous. So this idea that Facebook could pull themselves out and say, we don't have that much influence on Texas discussion. They're like, that's insane. Everybody in Texas uses Facebook. This idea that you're not a public square and you can just determine that on your own is garbage. So how do you feel about the arguments of Texas, the Texas Nationalist movement versus Facebook? And did I summarize that correctly?
Yeah, I mean, I think one of the fundamental concepts, and this comes back to constitutional interpretation, is, basically what jurisdiction are you subject to, right? So you can't just be sued in any court in the country. You have to have some contact with that court, and that might be a transaction, it might be presence, it might be living somewhere. Generally, the law say if you're domiciled in a state, if you live there, you're subject to lawsuit there. But then there's a number of cases that say if you have systematic presence in a state, then you start becoming subject to jurisdiction as well, right? So, let's say you had a trucking company and you were on the border of state A and state B, and every day your trucks were going into state B. The court would generally hold that you would be subject to lawsuit in state B, at least relating to your trucking activities, right? Because your trucks are in state B every day. Right. And I think that's the analogy they're making here, right? Facebook, I mean, there's people in Texas on Facebook every day, and they are constantly there, right? So the argument to me that Facebook says, hey, I don't have contact with Texas such that I can't be sued there, that seems like a tough argument to make. Now, will courts look at various things with a change of venue, right? Where are the witnesses at? Where's the information at? what's fair to the parties. So there's a weighting factor. So all that weighting, that's going to be the judge's discretion. So it's hard to predict that. But the bare fact or idea that Facebook says, hey, I can't be sued in Texas because I'm in California, I think they're going to have a hard time because they're so constantly engaged in commerce in Texas and other states, right? So I think that's going to be hard for them given their size. If they were a smaller company, had more sporadic dealings with Texas, maybe that would be a better argument. I see that being a hard argument for them to make on that level.
Oh, interesting. So the Texas nationalist movement may have a strong argument in saying, although you're domiciled in California, you have so much ubiquitous activity here in Texas that you can't say that you're not.
Yeah, I mean they must have advertisers in Texas. They probably have employees in Texas with remote working and all. They probably have lots of different connections with Texas, if I had to guess.
So there is a chance they may get to the secondary issue,
yes,
of if secession's legal or not, and they may just fight this out on where the venue is, or if you can even come after me for
sure.
Okay. Provided that they somehow did get to the secondary argument. My understanding is Facebook is saying secession is illegal. It's unconstitutional. Talking about it is wrong. How do we know that? Because Texas versus White said so. The only Supreme Court case that even mentions secession. And what the Texas nationalist movement, and at least what we in CalExit have said, is Texas versus White says secession is legal with consent of the states. Facebook completely omitted that phrase and acted like Texas versus White says, nope, you can't do secession in any possible way at all, and any sort of discussion is wrong and bad. When actually Texas versus White says there is a legal pathway. If Texas versus White by the Supreme Court says there is a legal pathway, then that means you can't say that any discussion of secession is unconstitutional because the Supreme Court did allow a pathway.
Yeah, I think one of the fundamental principles for the audience to understand is generally, the Supreme Court opinions are viewed to be binding on whatever was necessary for that case. So if we go back to Texas versus White, they did make a lot of comments, but ultimately they talked a lot about the fact that Texas legislature just up and announced they were leaving the United States. They had a referendum, and then they unilaterally said, hey, we're out of here. So we can probably think that that's good law, right? There's no reason to believe that the portion of Texas versus White that says if your state legislature just announces we're leaving the United States and we're gone and nothing you can do about it, obviously that seems to be, well within established law. The other question is, can the states, through consent or agreement, leave the United States? And Texas versus White, to me, seems to leave that door open, right? They talk about the consent of the states. Also, I think it's important to note, if we go to the U.S. Constitution, which is the fundamental document in this, Article 5 says it can be amended. And the Constitution has been amended 20 plus times now. So the founders, when they set this document up and had their original agreement, they realized that things would change over time. Yes, there is no explicit provision in the Constitution that talks about how states exit. There's provisions on adding states, but there's not a provision on exiting states. But the next amendment could be a provision that talks about how do states exit, right? That could be a constitutional amendment. Or the Constitution contemplates that there is a process for a constitutional convention. So at the convention, there could be a complete rewriting or a new agreement among the states. So to me, if the people agree and if the states follow the amendment process of the U.S. Constitution, I see that door being open, right? And so Texas versus White says basically you can't just openly rebel, you can't just unilaterally leave. But this is supposed to be a free and democratic republic, and you are supposed to be able to voice ideas and have opinions. And even if they are, not the mainstream opinions or different opinions or opinions that there's a growing consensus for. I mean, if we go back, to the civil rights movement, right? A lot of people, and even the pre-Civil War era, people were for things that, some people are for it, against it. And the minority, as people learned and people got more educated, their opinions and viewpoints changed. So to just say you can't discuss something that may be a future possibility, future constitutional amendment, I mean, that seems to be against the fundamental principles of the United States, right? You can bring your opinions forward as long as you are nonviolent, you follow the rules. The First Amendment guarantees freedom of speech. So, just to say, hey, I want to amend the Constitution to do X, Y, and Z doesn't seem like that much of a stretch, right? We've done it 20 plus times. People have got together and built the momentum and amended the Constitution. So, could you build the momentum and either call a constitutional convention to rearrange, the Constitution? You could potentially, it says amend the Constitution. Maybe you amend it radically. You delete it. You rewrite it. I don't see why that can't happen. Article 5 contemplates that you could potentially have a constitutional convention where you fundamentally rewrite the Constitution, or you could have a amendment that completely changes the way the Constitution works.
So we could do the amendment process, which basically allows for anything. The question Texas Nationalist Movement, I think, is saying is, you can't say discussing secession is unconstitutional because the Constitution literally says nothing about it. Is that a fair statement or an incorrect statement?
Yeah, I mean, the Constitution certainly doesn't prohibit talking about secession. It doesn't prohibit saying that's what you want to do. I think Texas versus White makes it clear, again, that a state can't just up and do it. One state acting unilaterally can't do it, right? But, can you have a referendum in your state to say whether your state supports it or is against it? I don't see where that's prohibited. Whether you want to try to start the constitutional amendment process, and get enough state legislatures on board. I mean, that's how you do that's one of the avenues to a constitutional amendment, right? Either 2/3 of both houses of Congress do the constitutional amendment, or the state legislatures do it. So it seems to me fundamentally in line with the Constitution that state legislatures would have to discuss this. Again, a discussion about an amendment or change to the Constitution versus a discussion about we're just leaving. Texas versus White seems, it's pretty clear. You can't just leave.
Sure.
But could you start the ball towards saying, hey, let's rearrange things? I personally don't see anywhere where that's prohibited.
So when we look at Texas versus White, it says you can secede with consent of the states. Obviously, that could mean the amendment process. I've argued it could mean something other than that, just because they already knew the amendment process.
Sure.
They didn't say the amendment process. They just said consent. I mean, why use the word consent when you know the amendment process? It's been enshrined for a century before you argue Texas versus White. Mm-hmm. Lawyers are supposed to use the plain language rule that goes back 2 centuries, and yet he did not say amendment process. He said consent. Why would a Supreme Court judge do that? Why would they not use specific language unless it might be open to interpretation?
I think there's an argument there, right? And I think, if this issue is ever fully developed and brought before, courts of competent authority, a court that can make a decision on this, I think that's one of the legal arguments, right? Is here's what the U.S. Supreme Court said, right? Because again, one of the roles the U.S. Supreme Court takes is to interpret the Constitution and help people understand where the boundaries of the law are. So they can act in accordance with it. So you're right. I mean, there is language there suggesting something other than the amendment process. How far that goes, what that looks like, what that is, obviously, they didn't tell us what it is, right? They just talked about the consent of the states, implying that there was some way, some avenue through consent of the states. But the door looks open for arguments at this point, right? And where that goes, that's going to be fought out in the court system. And when you don't have a lot of guidance like this, it's hard to predict where it goes. But you're right. I mean, I agree with your notion that the door is open to something other than the amendment process based on that language. What that is, what that means, they didn't tell us.
We don't know. But because they didn't use the word amendment and because the amendment process was defined, we can now question, why did you not use that word? You know what it means. If that's what you meant, why didn't you just say it? You said something other than that. leaving it
That's
open
right.
to interpretation.
That's right. And then now that's where you start developing the legal arguments, and the two sides in a case would typically have contrary opinions, but you would come up with reasoning and decisions. And then ultimately, a court, assuming this was an issue they had to make a decision on, would have to, basically pick which argument they liked and set guidance, right? So that's how a lot of when the Constitution has been vague in the past and hasn't had direct answers, that's generally what's happened, right? People have litigated, and then the Supreme Court has stepped in and said, okay, this is what the four corners of the Constitution says. This is our understanding of it, and this is how we interpret it. And then people go forward based on interpretation. In this particular case, there's a wide door from interpretation because there's not a lot of cases on it. There's not a lot of guidance. So, yeah, we are sitting here with Supreme Court opinion that suggests something that's wide open right now because we don't know what it means.
Can I show you a few things, and then I'd like to ask your opinion?
Sure.
Okay. We're going to do a share screen. Everybody's going to see this at the same time. Sean has seen this. I haven't prepped Sean, so we're all going to be pleasantly surprised. So the first thing I want to show you, here's the Texas versus White thing, just because I like to cover the Texas versus White, blah, 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 blah. Everybody's seen this. There was no place for reconsideration or revocation except through revolution or through consent of the states.
Yes.
Now, we at Yes California have actually filed 3 separate referendums asking for California to secede, which were approved by Javier Becerra, Kathleen Keenely, and Kamala Harris. Kamala Harris is now the vice president. Becerra is also a staff person at the federal government. So 2 of these people who said, yes, you can secede, work for the federal government. And they literally quoted, there was no place for revocation except through consent of the state. So we have 3 California attorney generals saying, yeah, it says it. And apparently when they said that, that wasn't that offensive to the federal government because 2 of them now work for the feds.
Sure.
This is Abraham Lincoln's first inaugural address, Monday, March 4th, 1861. So this is the first speech Abraham Lincoln gave. And what's key is that this Texas versus White decision was presided over by Chief Justice Salmon Chase. Salmon Chase, who presided over Texas versus White, was directly appointed by Abraham Lincoln. So we see Salmon Chase saying, hey, you can have consent of the states. And this is the guy who was specifically picked by Abraham Lincoln.
Sure.
So when we look at Abraham Lincoln's first inaugural address, very first speech before the Civil War started, he has some phrases in there like, continue to execute all the express provisions for a national constitution, and the Union will endure forever, it being impossible to destroy it except by some action not provided for in the instrument itself, meaning there's not a way in the Constitution for it to break off unilaterally. Again, if the United States be not a government proper, but an association of states in the nature of a contract merely, can it as a contract be peaceably unmade by less than all the parties who made it? One party to a contract may violate it, break it, or so to speak, but does it not require all to lawfully rescind it? But if the destruction of the Union by one or part only of the states be lawfully possible, the Union is less perfect than before the Constitution. It follows from these views that no state upon its own mere motion can lawfully get in the Union. I shall perform it so far as practicable unless my rightful masters, the American people, shall withhold the requisite means or in some authoritative manner direct the contrary. So 3 different times Abraham Lincoln says, you can't leave a contract unless everybody agrees.
Yeah.
We look at Salmon Chase, directly appointed by Abraham Lincoln on the only case to discuss secession, and it says, you can secede with consent. Am I wrong in assuming there's some sort of ideological line between President Abraham Lincoln, who fought the Civil War, defined that secession is illegal, his very first speech saying at least 3 or 4 times, everybody has to consent before you can leave a contract, and then Salmon Chase in Texas versus White, the only Supreme Court case on secession, seeming to say basically the same ideological phrase. Am I getting this wrong?
Yeah, I think that's it. Now the open question is, what does consent mean, and is it unanimous consent? Consent of the states is that everybody has to agree, I think you have a pretty good argument that's implied by Chase's wording in the opinion. Versus, is it a majority consent? That's why, personally, I feel strong about the, amendment avenue, because that's clear. It says, two-thirds of both houses, and then 3/4 of the state legislatures, or it comes up through the state legislature and gets voted upon, right? So one way or another, you've got a clear path there with less than all of the states to potentially have a state exit. So yeah, I think there's a question of contract interpretation. What's interesting is, as we've developed corporate law, which is what I primarily do. I work with businesses. Often in our statutes that govern our corporations or LLCs, there's specific vote percentages you need to amend an agreement or change the rules or do things in different circumstances. So we've kind of built that framework in there. The Constitution, it has been interesting throughout the U.S.'s existence, because it's a very short document and it leaves a lot of stuff open to later interpretation and figuring it out. And this is one of them cases, right? And so both Lincoln and Chase and the Chase court are kind of expressing their opinion of what they think where they think the Constitution falls. They both went heavily on this consent concept. But then again, is it consent? Is it majority consent? Is it the consent level you need for a constitutional amendment? Is it unanimous consent? That's an open question that we just don't have much guidance on.
I want to ask you one last question, if I may.
Sure.
So Erwin Chemerinsky is the dean of 2 separate California law schools.
Yep.
So he started 2 separate law schools. UC Berkeley School of Law, which, as I understand, is pretty good, and UC Irvine School of Law, which is pretty decent. He's also named the American Academy of Arts and Sciences 2016. The National Jurist magazine named him the most influential person in legal education in 2017. Study of legal publications in 2016 and 2020 found Chemerinsky to be the most frequently cited American legal scholar. He's the top constitutional scholar in California, very well respected, multiple times cited, dean of 2 different law schools. And he said this: in theory, because it was a majority vote of Congress to admit California, in theory, a majority vote of Congress could approve secession. Is he right?
It's an interesting theory, but I think the issue with that is that it's explicit. The Constitution is explicit on how you admit states. And so it doesn't have kind of the sister or contrary provision in the U.S. Constitution. So that's the challenge with that argument, right? Is it's a one-sided provision. It only talks about the in. It doesn't talk about the out. Again, I think it's an argument that could be advanced in court. I personally wouldn't think that would be a frivolous argument to say, hey, if the in is a majority, then the out must be a majority by implication, right? And the founders just didn't include the additional language because, economy didn't have the time, it was a long document already, et cetera, et cetera. It seemed like that is an argument that can be made. I don't disagree with him in that's an argument that can be had. The challenge I see with that argument is just that it is very explicit about how you bring states in, and it's silent about how you take states out, suggesting that the process would be different. But again, that's just my initial opinion of it, right? And that could be developed in cases, and other lawyers and other jurists might disagree with me.
What if I could add a legal wrinkle?
Mm-hmm.
California was not admitted through the defined ascension process. The American government did not follow the normal ascension process. About 45 states did that. About 5 states didn't.
Yeah.
One of them, including Hawaii. Hawaii has been condemned by both Barack Obama and President Bill Clinton for the way that it was taken. California was kind of taken in a similar fashion. There was a de facto independent government here, a bunch of people following something they called manifest destiny, which said that white people had the ability to conquer all non-white people,
Sure.
came in and literally shut shot all the Mexicans, told all the Asians you don't get to own property, segregated all the black people, and committed a genocide against the indigenous. If we consider that every minority group was either attacked or attempted to be killed and not allowed to be part in the vote, and that the ascension process says you have to have everybody vote, and that the normal ascension process was not followed, bringing California into the Union. Actually, what happened was there was an American general who operated as a dictator and literally just ordered California to become a state. That is absolutely not the way 45 other states did it. Looking at that, could we argue, hey, you guys did such a haphazard job of allowing California in? Dictators, genocides, white supremacy. And then you just said, hey, yeah, simple majority vote, they're in. Maybe because you didn't follow the rules in the Constitution, we don't have to follow the rules to allow California out because of its unique history.
I think it's an argument too, right? I mean, the history matters, whether the process was followed, right? I mean, we certainly have times in the legal system where, we look at a process not being followed, and then because of that, legal consequences flow from that. I'm kind of analogizing that to some marriage cases, right? Sometimes you get a case where somebody dies and they have a big estate, they have a lot of money, and then there's an argument: was the marriage valid? Was the marriage not valid, right? And the court will go back years later and look at the underlying details and determine, was there a marriage, was there not a marriage? Then that determines who gets what assets in the estate. Could be a very similar argument here, right? We weren't validly, if California wants to make the argument we weren't validly married, we weren't validly brought in. That does raise that whole argument. And interestingly, as you were saying that, I know California has a unique history too, but it raises the argument with a lot of the states because, a lot of states had indigenous people, Indian tribes, and then they just kind of flooded west and filled a state up, and then they had to vote to become part of the U.S. And this is kind of the U.S. history.
Yeah.
It undermines kind of the entire system potentially by saying, hey, there wasn't valid consent of the governed even to join the union, right? The states didn't even properly apply to join the union because the numbers were rigged, right? Interesting argument, right? And very cutting edge, and something we just don't have the information on. But I mean, I do think more and more we're starting to hear people questioning, how the U.S. came into being, what the history is, was it done properly? All of that points to the potential of saying, hey, there is a valid argument things were not done properly because of these things that we are just starting to talk about more and more as a society. And then does that undermine the whole system? And I think that's an argument that maybe we'll see at some point.
They could argue, they didn't let the indigenous vote when they allowed states in, but a lot of the indigenous were wiped out. And when we get to California, there's more non-Americans than Americans by far.
Yeah.
And they're all told basically you can't vote. Nothing had ever been seen on that scale in America. I mean, they usually just wiped out all the indigenous, killed them off, or they were too scared to participate. These people were saying, I'm here, I'm ready to be a citizen, I want to vote. No, you can't. Mm-hmm. Secondly, California was ruled by 5 generals, and the last general literally just said, it's time to be a state. That never happened with any other thing. Thirdly, if we look at Hawaii, so Bill Clinton and Barack Obama have said that the way Hawaii became a state was wrong. It was an independent country, and then it was effectively overthrown as people disenfranchised and forced to be part of the Union. California was independent from Mexico and America from 1836 to 1846, according to every California historian. It effectively threw off the last 3 Mexican governors and was effectively independent. Given that it was effectively independent and recognized by historians for 10 years and then overthrown, doesn't it make it somewhat similar to how Hawaii was an independent government, militarily overthrown, and then its people not allowed to vote and forced in, which 2 American presidents have said is wrong?
Yeah, I think it's an argument. I think it's an argument that can be developed. So yes, I think that argument sits there. And I think it may be one where, part of it depends on which court, who's sitting on the court at the time they see that argument, and, how far into the future do we go? Because I think these types of arguments where we look at the fundamental history of the United States, they're becoming more prevalent. So they're becoming more accepted. So I think part of this is going to be just a function of who's on the court where society is. But I think it's a valid. I think it's an argument to be made, right? That this just wasn't done right. The history's not there. We did not consent. Therefore, everything gets unraveled because there never was a valid marriage. Going back to the analogy, right? So I think it's an argument that can be made. I think there's potential support for it. Obviously, you've found some authority for that. There's people starting to open up to that idea. The question is, can you convince the court to do it?
One last question. Texas wanted us to file an amicus curiae for their court case, and we wanted to say, secession is legal. Chase said so. How does one go about filing an amicus curiae? How much does that cost? Could you walk us through a little bit of background on that?
Yeah, I mean, it's just basically they view these as quote unquote friend of the court briefs, where the appellate courts often welcome this, where you as different groups, societies, institutions, individuals can offer their opinion and their legal analysis, for the benefit of the court. So that is a process. These things don't officially have any weight, because they're not part of the direct process. But the courts sometimes will go through these briefs and pick pieces from them or use parts of the analysis. There's typically a timeline to do it. There's a process with the U.S. Supreme Court, so you research that and see what you have to do and when you have to send it. I don't do enough appellate work. I don't think there wouldn't be a high cost with it. The biggest work would be preparing the brief and getting it ready to go. So I don't even know if they would. I don't even know if they often charge a filing fee for these briefs. So if they did, it would probably be a small fee. You're not looking at a substantial amount, most likely. So the question is, can you prepare it? Can you put your legal arguments together? But if you can do that, then you could just hand it in as a friend of the court and say, here's some additional materials we think you might want to consider, and then determine whether they consider that or not. But that's very common for people who are interested in an important issue like this to add their voice, so that the court can understand what they're saying and what other viewpoints are.
So we're in California.
Yep.
But if we wanted to do an amicus curiae to help the Texas Nationalist movement, we would need to find a Texas lawyer because the case is being argued in a Texas court. Is that right?
I don't know if you have to check the rules there, but I think that they would. I think they generally accept. They're open to a wide group, so you're not actually. You have to. I don't think you wouldn't actually. You would just be depending on who is offering the friend of the court opinion.
Yeah.
You don't necessarily, if it's an individual offering it, you don't even need to be, you can just do it as an individual, right? Individuals often file lawsuits on their own behalf, so you may not even need a member of the bar if you offered the friend of the court brief as a individual. So you may want to look at that and that procedure. But generally, individuals can represent themselves in court, except in the case of like corporations and small companies and things like that. Sometimes you then have to get a lawyer, but in general, individuals usually can go before the court themselves. So if you did this brief, as individuals, maybe even send in multiple briefs with similar notions, you might be able to do that. You have to look at the filing procedures there, but I think you probably could do it as individuals.
So it's possible that me as an individual could file a amicus curiae in Texas.
Yeah.
And if I needed help, I need to find a Texas lawyer who does appellate work.
Yeah, because you're going to be making appellate type arguments. I mean, it's going to a trial court, but you would be making, pretty advanced arguments about the law. So you probably want a lawyer that is familiar with the appellate law, because they would be thinking about the arguments and, how to phrase it and how the law would be developing in the future.
We just want to have something saying, Texas versus White says consent of the states is there.
Sure.
Period. And please recognize that.
Yeah. Do
you think that's a worthwhile attempt, given that this may just get argued out in other arguments before they even get to that?
If I had to guess, and this is just a guess,
Yeah, I get it.
Yeah. I'm guessing the court's not going to want to get to this issue, right? It's a hot button issue. It's sensitive. There's not a lot of guidance on this. My guess is if the judge can find a way to address the case without getting into what the boundaries of secession are, I think they're going to. I don't think the judge, it's not the type of issue that a judge typically want to pick up unless they have a political reason to want to weigh in on this issue. This is the type of thing that most judges, I think, would sidestep.
This is Texas.
Yeah. You don't know.
We're a lone state. Remember
Yeah.
when we were independent? I mean, maybe there's a Texas judge who has a wild hair. Is that possible?
Could be. Yeah. You got to look at the history.
I want to do it.
You got to look at the history of the judge, and you can see even with a lot of the recent cases on the coronavirus and the shutdowns and the government mandates and all that, a lot of that the cases were breaking largely on whose political appointee the judge was, right? So that's an important factor, right? Who put this judge on the bench? And these judges should be independent of politics, but you can see a high correlation between who appointed a judge and which direction they broke on different cases.
Lady Justice isn't always blind, as we're led to believe.
Yeah, I mean, there's a lot of factors that go into this, right? And I think, sometimes, it's just, you can see the correlation there, right? Why the correlation is there, I guess everybody can guess, but you can see certain cases break certain ways based on, which political parties, some of these judges may be aligned with.
They certainly say the Supreme Court's the most conservative it's been since the 1970s. So
yeah,
we've started to see some cases be overturned with 40-year, 30-year precedent the moment that happens. So yeah, you can clearly see a line of politics influencing judicial decisions when they're supposed to be independent of that.
Yeah, I mean that's the way the system's designed, right? And the way the lifetime appointments of the Supreme Court, the fundamental concept was that the president will put them on there, but yet they would then be independent, right? Once they're in there, they would be independent. And that's the way that, the system is designed to work, is that the judges, the appellate, judges and the Supreme Court justices, they should be independent of politics largely. They should be making decisions based on precedent, rule of law, the whole system. But, in practical reality, we see that things move depending on these fundamental viewpoints, right? And there was a lot of discussion every time a Supreme Court justice comes up. There's these whole lines of questions about what are their fundamental beliefs of how the legal system works. And, there are differences of opinions about, whether the Constitution should be interpreted directly on the words it says and no additional stuff, or whether it's a living document. You see all these different theories going back and forth. And there's a correlation between those opinions and political parties. So I'm not saying it's a political process, but here in the U.S. there are just differences of opinions, and they flow through into the court system.
So people forget that there isn't a black or white issue for all legal questions. Some legal questions have different opinions from very brilliant legal scholars who can go back and forth arguing left and right. And so it's really hard to say this is the right opinion, because you got smart people on both sides saying no, and they both have tons of case studies backing up what they said. Yeah. That happens occasionally in law, right?
That happens often, and even the Supreme Court, it's reversed itself many times, right? It goes one direction for a while, and then they go back and they look at it and they say, hey, they don't like to reverse themselves, but the Supreme Court does go back from time to time and say, hey, we were wrong about this line of cases. We just went the wrong direction. And now we're looking back through the wisdom of time, and we're saying, hey, we got it wrong. We interpreted the Constitution wrong, or whatever. So, I mean, the door's open to that. And then it's interesting because, you say the U.S. Supreme Court is very conservative right now. Does that favor secession, or is that against secession? It's hard to say, because one theory is, the conservative view is keep the United States together and nobody can leave. And the other view is, that this was a amalgamation of states who consented to the Constitution. So do you go more to a states' right view? And it's hard to predict, particularly on this issue, because there's so little case law and arguments on it.
Yeah. We don't know. The Supreme Court is the most conservative since it's been the 1970s. New York Times, other places have said that, judicial scholars. I would point out that Marjorie Taylor Greene, is a sitting member of Congress and a conservative, and Ted Cruz is a sitting member of the Senate and a conservative. They have both talked about the right of secession.
Yep.
And the last time we've had sitting senators and sitting House members talking about the right of secession was in the 1860s. They're both part of the Conservative Party. So there might be some ideological leanings of the Supreme Court, given that other people in that political camp are already pushing that way. We don't know.
We don't
But
know. It's hard to read, and they, in the Supreme Court, they usually are careful about, not being public about their opinions in advance of cases and not really trying to advance arguments, right? They try to hear what comes in front of them and give answers rather than foreshadow what's happening. But yes, I mean, I think there's, there's a possibility there that could, that may be an alignment that's more beneficial to this argument.
didn't we see the African-American male justice say after they undid gay marriage that all the woke liberal policies need to be reviewed? I forget his name, but he literally said something like after they did that, he goes, and now we need to look at everything else. That is certainly not a Supreme Court justice keeping their opinion to themselves. I mean, that terrified people.
Yeah, it's unusual. It's not saying it hasn't happened in history, right? I mean, some justices have, talked more outside of the court than they have. A lot of times they talk within their opinions, but it's unusual. It's just not the standard practice.
Not a good sign.
Yeah.
Okay. We'll leave it there. Thank you, Sean, for everything. What would you like to leave the audience with? How can they find you? Is there inspirational messages or philosophical sayings you want people to think for the rest of the week?
Oh, I think this is, this is an interesting topic. And while the idea of secession and breaking apart America is, some would view it as anti-American. The other view is maybe this is the most American thing you can do, right? Consent of the governed, independent people making the decisions on how they want to be governed, right? These are ideas that go through the Constitution and the Declaration of Independence. So, I think it's interesting that this is getting a lot of discussion now. And, I'm glad that your organization's in it and, thinking about it from the legal avenues and how do we get to an agreement and what's the right path forward, right? I think that's the right attitude. Not we're going to force this to happen. We're going to figure out how to make this happen the right way. But I think I think it's very healthy for the country to have this conversation, right? Well, whatever way it comes out, wherever people end up, we should be encouraging people to discuss the things they want to discuss. We need more of that in our country, right? That's what makes that's one of the great things about the Constitution is that we are hopefully allowing people to express their opinions so that people can change their viewpoints and get to the place they really want to be. So I applaud the effort to get the conversation going. I think it's a great effort. You've done some amazing research. I always learn stuff every time we talk because I'm not as, I don't go as deep down some of the California avenues and other things that you do. So it's always great. But I'm glad people are listening. I'm glad they're viewing. Look forward to seeing the YouTube comments. If people are interested in business and business law, that's where I spend most of my time when I'm not talking about freedom issues, because to me, the two are interconnected. So yeah, feel free to check out my law firm and you can see if there's some resources there. We have a YouTube channel as well. And so hopefully there's some helpful stuff there for the right people.
That's R. Sean McBride. You can contact him at hello@rsmlawpllc.com. You can also call him at 214-418-0258, or you can go to rsmlawpllc.com. You can see it right there. As you've seen, Sean does not bite, and he's pretty nice. He's an easygoing guy to talk. Well, he did bite me one time, but other than that, he's pretty easygoing. Sorry, I had to let that out.
Yeah.
He might bite you once, but then after he gets a feel of your flesh, then he's like, okay, we're cool. So I think it's worth it. I'm missing my left foot, but hey, he's been a great advisor. So
yeah.
Well, he doesn't bite. He's a great guy. He's easy to talk to. Also, the thing I like about you, Sean, is you have a curious mind. You're not just like, ignore that issue. You're like, oh, that's an interesting,
Yeah,
that's an interesting. I love that.
I think that attitude of being curious and learning from others is very important, and I think we can all benefit from that.
We'll leave it there. We'll talk to you soon. Thank you very much, Sean.
I enjoyed it. All right. Have a good one. I'll talk to you soon.
All right. You too.